This is brought to you by Cook County's Commission on Human Rights. The purpose of this video is to describe what no longer can be asked on housing applications and the dispute resolution procedure associated with the Just Housing Amendment of the Cook County Human Rights Ordinance. On April 25, 2019, the Cook County Board of Commissioners passed the Just Housing Amendment to the Cook County Human Rights Ordinance to prohibit housing discrimination based on an individual's covered criminal history and require landlords considering an individual's covered criminal history to perform an individualized assessment of an otherwise qualified individual's criminal conviction history prior to denying them any application for housing. The Just Housing Amendment went into effect on January 1, 2020, with initial enforcement on February 1, 2020. The Just Housing Amendment includes several newer procedures for housing providers and seekers to be aware of and practice. The Cook County Commission on Human Rights wants to ensure that the public understands these procedures as clearly as possible. We are going to walk through some of these procedures together. In compliance with the Just Housing Amendment, there are new or different requirements for processing housing applications. To begin, landlords can no longer include a question on housing applications that asks whether an applicant has a criminal background. This is because any aspect of justice involvement should not be assessed during the first step of the screening process. Second, before accepting an application fee, a landlord must provide the following information: Tenant Selection Criteria, which describes how an applicant will be evaluated to determine whether to rent or lease to the applicant. The applicant's right to provide evidence demonstrating inaccuracies in the applicant's conviction history or evidence of rehabilitation as defined in Cook County Code Section 42-38A and other mitigating factors pursuant to Section 740.110 and a copy of Part 700 of the Commission's Procedural Rules or a link to the Commission's website with the address, email address, and phone number of the Commission. Turning now to the dispute resolution procedure, this is a process which allows individuals with an opportunity to dispute inaccuracies within a background check, if one is run as a part of the screening process prior to the individualized assessment and prior to any denial of a housing application. Within 5 days of obtaining a background check on an applicant, if it has been run, the housing provider must deliver a copy of the background check to the applicant. The housing provider must complete delivery in one of the following ways: in person, by certified mail, or by electronic communication, example, text message or email message. The applicant has 5 business days to produce evidence that disputes the accuracy or relevance of information related to any criminal conviction from the last 3 years. An example of instance in which a background check might be inaccurate is when the applicant has a common name. Examples of mitigating factors that applicants can provide to landlords might include court-issued good conduct certificates, employer recommendations, education or vocational training, participating in programs that assist with the transition back to the community, letters of recommendation from community-based organizations, faith-based organizations, etc. Following the applicant's opportunity to dispute, the landlord shall conduct an individualized assessment to determine whether the individual poses a demonstrable risk. A landlord must either approve or deny an individual's application within 3 business days of receiving information, disputing information in the criminal background check. Denials must be in writing, provide an explanation as to why, and contain a statement informing the applicant of their right to file a complaint with the Commission. If you have any questions or believe that a landlord or housing provider violated the Just Housing Amendment, contact the Cook County Commission on Human Rights. If you are a landlord or housing provider in Cook County and are looking for clarification, please contact us. We recommend you learn more on our website at bit.ly/HR Commission, and more specifically about the Just Housing Amendment at bit.ly Just Housing Amendment. Our email address is human.rights@cookcountyil.org. landlords.gov. And our phone number is 312-603-1100. This does not constitute legal advice and is for educational purposes only.